Hello, my name is Kay Ainsley. I'm with MSA Worldwide, and I am Vice Chair of the International Committee. I'm filling in today for our chair, Larry Weinberg from Castles, who has a scheduling conflict. Thank you all for joining us, and welcome to the first of a series of webinars that the International Committee will host in 2024. Our thanks to Tao Chu at DLA Piper for leading this effort. If you'd like to learn more about the International Committee and how you can become involved, or if you'd simply like to be put on a list to receive more information on international activities and events, please reach out to Tony Padullo at School of Rock, who chairs the membership subcommittee, Alan Catlett at IFA, Larry Weinberg, as I mentioned, our chair, or you can contact me. And now I will turn the mic over to Allison McElroy of Kaleidoscope Growth Advisors, who has a dual role today of being both the moderator and a speaker for today's program. Allie, take it away.
Thank you, Kay. So our webinar today is on the topic of the art of the deal, negotiating key terms in international franchise agreements. Now, our approach, we're going to focus on a few key issues. We could spend multiple days on international franchise agreements and negotiations, but we have 1 hour. So we're going to dive deep on a few key issues and share some different viewpoints on those. Our agenda is very simple. We're going to open with some introductions, address a couple key questions to start, and then move right into the deep dive into that focused discussion on a few key issues. A little bit of housekeeping. If you do have questions, you have a Q&A button within the webinar. Feel free to put questions in there throughout the program. We are going to do our best at multitasking and take a look at those and answer them as we go, and also have set aside some time to address Q&A at the end. So we'll do our best to address as many questions as we can. If we don't get to everything, the panelists are open to you contacting afterwards, and we'll share our contact information. Just a practical note of please make sure you identify yourself if you would like someone to get back to you. If you put a question in anonymously, we don't know who you are. Okay, let's jump right in. So our panel, it is such a privilege to be on this panel as a moderator and a contributor. My co-panelists and the speakers today have a wealth of experience that bridges the whole globe, as well as business and legal perspectives on negotiating franchise agreements across a number of different sectors. The speakers today are Joyce Mazero, who's the chair of the Global Franchise and Supply Practice Group at Polsinelli, and Justin Vartanian, who's General Counsel and SVP of International for Planet Fitness. I'm Allie McElroy. I'm the founder and CEO of Kaleidoscope Growth Advisors. We are a consulting and advisory boutique working in a shared success models with growth-oriented brands that are expanding through franchising. I have almost 20 years of experience in franchise and international business experience in a number of different roles, ranging from outside counsel, in-house, and then also executive positions across HR, operations, and development. From a franchise perspective, I've worked with over 30 brands in different sectors across at least 30 countries. And that includes a number of different executive roles with Lyft Brands, a multi-brand fitness platform, including Snap Fitness, where I served as Chief Legal Officer, as well as spent some time as Chief Global Development Officer, and then President of International. I'm also co-author of a forthcoming book with Bill Edwards talking about international franchising called Brand Global, Own Local, The Art of International Franchising, which is a story-based approach to all the wonderful and difficult things that happen when you are expanding your brand internationally. So with that, Joyce, would you share some of your background? Would you introduce yourself, please?
Sure. Sounds like a great book, Allie. Can't wait to read it.
Thanks, Joyce.
Got a great co-author too. I'm Joyce Mazero. I've been practicing in the international franchise area for more decades than I really want you to know. So I'm not going to go too much there. Have been doing deals both on the franchisor and franchisee side, probably in more than 60 countries. I don't think there's any issue I haven't seen. I'm not sure I've resolved all of them. They continue to come up and repeat themselves. So hopefully we'll get answers to a lot of things that happen internationally. I'm very pleased to be here and to share some thoughts about these issues, and I'll turn it over to Justin.
Hi, everyone. Thanks for joining us today. So I have a kind of unique role where I run our legal departments, and I also, as of a few years ago, am also running our international division. So we at Planet Fitness, we're in the early stages of our international growth. We're in Canada, Mexico, Panama, Australia, and we expect to be in Spain and New Zealand by the end of this year. With hopefully, we're publicly traded, so what we've told our investors is maybe 1 to 2 new markets per year, which doesn't sound like much, but it's pretty aggressive. Another unique aspect about us, we are 90% franchised, but we do own a couple locations in Canada directly. And we're also minority investors in our partners in Mexico, Australia, and Spain. So it's a bit of a different dynamic, and hopefully I can add some insights there. Before joining Planet, about a decade ago, I was primarily an M&A attorney. So I had the opportunity to work on deals as outside counsel, in-house counsel, managing outside counsel, and in my current role, which is more or less often as client when it comes to international. So I think being able to wear those different hats has given me a broader perspective of what success looks like negotiating these deals, and what can come up along the way. And hopefully we have some interesting insights for you today. So thanks.
Thanks, Joyce. Thanks, Justin. All right, let's jump right into it. I want to start with just laying a little bit of groundwork on international negotiations. And a first question for our speakers today is how, from a high level, how do international negotiations differ from domestic? Justin, can I toss that to you first?
Sure. Well, first off, I know it does, sound like the all-time classic law for marketing pitch of like, well, international is just different. But having experienced it for some years now, unfortunately for us, it's true. It really is. Saying it's different is easy. Unpacking what that actually means in a practical way to try to be helpful to you is definitely not as easy. I think one of the biggest ways is you have to be, it's a different style required to negotiate. Chances are you've negotiated a lot of deals if you're on this webinar, and you have a style, you have strengths and weaknesses, like it or not. I think some self-reflection is important because if you can't identify those tendencies, it's going to be really tough to adapt to negotiating with what can be some very different cultures and customs. So one of the biggest things I've noticed is another obvious one, but language barriers are huge. They amplify everything. Myself personally, as a recovering attorney, I know sometimes I lack empathy and I can be too matter of fact. And sometimes you're discussing a person's life's work, so I try to be aware of that. I also, I'm not good at it, but I like to try to break the ice with humor and use humor to build rapport and kind of disarm the other side of the negotiation, usually at my own expense. And I'll tell you, that has not worked well for me via translators. So that's something to keep in mind. I think being humble, concise, and genuine, not going to steer you wrong. Doesn't mean you need to pretend to be anyone else. Doing, hopefully this is a long-term relationship and that kind of shines through eventually. So that doesn't work either. I'd say just keep it simple. State the obvious. Your approach is going to vary incredibly widely based on the circumstances of the relationship. Hopefully for the long-standing relationships you have, like we've been in Canada for a decade, we just kind of have a regular cadence, and it's not something I have to think about quite often. The new relationship's the real challenge. It's kind of like a first date, for lack of a better example. You're trying to establish some rapport, learn as much as you can, and really just try not to embarrass yourself, or at least that's my goal. First dates were hard enough for me in English, so the idea of adding a language barrier scared the hell out of me. So, a few quick thoughts. I know it's an old school take, maybe another obvious one, but being there in person for early negotiations has been very helpful in my experience. It tells the other side that you're important enough to me for me to make the time and effort to come see you. Knowing it, this might just be a wasted trip. It helps you read body language. I think that's really tough to do over Zoom, or easy to misinterpret the room. You know, you can't really read the room via um, via Zoom with so much that goes unsaid. People tend to be kinder in person. I don't understand that one. I don't pretend to, but I notice less aggression and more kind of rapport in person. And lastly, it allows for some kind of good human moments, you know, grabbing a coffee, grabbing a snack, small talk during breaks that you don't organically get on Zoom. Speaking of snacks, another great way to build rapport and relationships is the sharing of food. Food is like it's a universal language. One side is kind of sharing their culture, the other side's hopefully showing respect and appreciation for that culture. And on that note, I was in Asia with a prospective partner. We had a very adventurous meal. I'm not a picky eater whatsoever, but it stretched the bounds of my my taste. So by the end of that meal, they kind of walked away like, this guy cares. This guy is at least tried to adhere to the customs to the best I understood them, and was eager and didn't kind of flinch at like, oh, they're different. This is different. I paid for it the next morning when I tried to order a very plain meal, eggs and breakfast potatoes using the native language, where they promptly showed up with scrambled eggs and a whole plate of French fries at 7:30 in the morning. So I've definitely set Americans back, at least in that regard. But yeah, that leads to my last point, which is effective communication is the biggest hurdle. Getting a good, experienced business negotiator makes a huge difference, and it's worth the money. So I'll leave it at that.
Great, thanks, Joyce.
So I think that a lot of it is the same as you would conduct domestic sales. It's just incredibly more intense. I think what we do domestically and what's important internationally is to set expectations. And I won't address the cultural because I think Justin did a good job of bringing that up. But there are a number of different, I think, categories of intensity. So number one is all about timing. And this has to do with setting expectations about timing, because due diligence is different. Due diligence may be certainly more deep, harder to do, and not as available in terms of the information that you can readily get on public source availability, and you'd have to go on the ground to get that information and seek specific references and interviews. So it's definitely more intense there. And what you learn about your prospect needs follow-up right away so that you can understand the meaning of it in terms of assessing risk with that prospect. Other areas where it's different is we're used to a domestic regulatory system where, you know, conducting sales, once we have the FDD and registrations, everybody's ready to go. As you go country to country, you're going to have to deal with lots of different regulatory requirements, which really affect the timing and the expectations, because in some cases you'll have to put together a disclosure document, you'll have to register, you may have translations involved, and some of the local issues that come up, like the treatment of guarantees, you know, specialty areas, including exchange controls. All of these start to bear on a deal that in a domestic context, you have some expectation of how they're going to turn out. And in an international context, you may have to turn on your heels and pivot to a default position because you can or cannot do certain things, or certainly as quickly as you would like them to do. I think hidden costs for the client is extremely important to know, so that they can take that into consideration in setting up the economics of their deal. And then at the last point that I think is so important, because I see this happen over and over again, is that I think that the business people and the lawyers think that the other side, respectively, know the deal points and understand each other at the end on what the commitment is. And over again, I see that this is not the case. You know, people don't understand the gross up provision. They know it's in there, but when they start to get an invoice, all of a sudden there's an issue. If you use a standby letter of credit, they understand what that means, but then there's a whole negotiation with the bank. So going through the process with the client is while they're trying to get through this, because they know what it's going to take. And some countries are really easy and the circumstances are easy. We just did a deal with an existing franchisee in the Philippines that took, a week. And I am on my third reiteration of a deal in India. It was going on like in its third year. So it is constant. And that's with like 3 different parties. So I think it's being able to work with the client and business people, understanding that there's going to be some bumps in the road, even no matter how much you try to forecast the deal progression.
Yeah, such good points. And my experience is very similar. Lots of points of commonality with both Joyce and Justin. And say a couple of things that really stood out is what you were sharing and that align with my experience is that cultural aspect in the language is both obvious but also really difficult. And really understanding the culture, both in terms of business culture of how negotiations are conducted, how people interact, what the expectations are, as well as the conversations around what might need to change to the local market. It has been a significant portion of succeeding in achieving deals and growth internationally. The other things that come to mind, I think that Joyce and Justin, that you both kind of touched on, is that different companies expand internationally in different ways. Is that a direct franchise where you're dealing with individual unit franchisees, say in Canada, maybe Australia, or are you dealing with a sophisticated large party in another region that maybe also has large multinational experience? And so that range of the structure you choose and the person you're talking to can be really wide when we're talking about international. I think most of what tends to be different is that the fundamental concept coming from, if you're new to international and you are growing, say through a master franchise relationship, is if you've been well trained on your US franchising, we know that, where franchising is all about structure and terms, and there's limited negotiation of a franchise agreement. Whereas in international, you're dealing with a different context, and just the fundamental fact that international franchise agreements are typically much more heavily negotiated might come as a surprise, or and the fact that international deals often take longer. Joyce, I will tell you, I don't think I've ever done an international deal in a week. That's impressive.
I meant it to be impressive.
But if someone told me and said, oh, it took us 3 years to get a deal done in Japan from the moment we met, that is pretty fast. And so those are some of the things. Those are a handful of things that, when I think about the difference between international and domestic, come to mind. Okay, so the next question, really the meat and the heart of what we wanted to spend some time talking about today and dive into, are what are some of the key negotiated terms in international franchise experience? And the 3 of us, in preparing for this webinar, met and talked, and we know there's a whole agreement and all of its pieces are important. Please don't delete anything just because you don't hear us talk about it today. But what we did was we picked just a few of the key terms that come up regularly and are important for both sides and both parties in order to ultimately achieve the goals that you're setting out on when embarking on a new partnership. So I'll exhibit my American cultural approach here, which is typically to be very direct. And so we've put on the screen for you very directly, we won't make you guess, the handful of key terms that we are going to talk to today, time allowing. We should get through these particular terms, and those are system change and local market adaptations, getting paid, development schedule, and the important consequences or next steps when the development schedule doesn't turn out quite as planned, damages issues, marketing and ad funds, and dispute resolution. So what we'll do here is we're going to dive into essentially an open discussion amongst the panelists about these issues, with each of us sharing our different viewpoints and experience in these particular topics. So Justin, can I ask you to kick us off with talking about system change and local market adaptations?
Absolutely, happy to. I think this is a fun one. It's incredibly challenging, but it can be really rewarding when it goes well. I mean, this is about how to create a healthy tension between the push of staying true to the model and the pull of localization. There's plenty of examples where that balance was way off, and either an agreement or negotiation fell apart, or the agreement got finalized and the venture failed. So I'm not going to talk about those, but the balance there is what's important. And the agreements where you set the guardrails. So I think that's something that's should be our focus. Naturally, as franchisor and the client, my first instinct is it all runs through me. We created the brand. You, lucky franchisee, are fortunate enough to be renting it from us. Just run it the way we taught you. You want to try something different? Come talk to me. I'll think about it. I would bet, based on negotiating dynamics, there's a lot of agreements out there that are just like that. Probably some of your agreements are just like that, but that's not really how you build a successful, mutually beneficial long-term relationship. It's tough because, you know, if you're a franchisor, you've hopefully created something special, something that's worth putting out there to the world. And when it's done right, it works, and it makes money for franchisor and for franchisee, and it serves a need for a consumer. But on the other hand, if Planet was not a US brand and it came here and said, okay, we got to localize, we might end up taking what's special about our model and turning it into just any other gym in the US. Say, like, well, some gyms have classes, got to have those. Some gyms have cycles. Some gyms have a pool. Like, okay, we got to do all these things. So I worry about localizing, and I think my approach has been, I don't know if it's the best approach, but it's so far hopefully working, is to have your partner very early on fully immersed in your brand, how it was created, how it has evolved since then, where it sits within your industry and competitors, and also hearing from fellow franchisees who don't have anything to gain by you deciding to become a developer. If you can kind of ground your partner in the sense of who you are, you're going to have to trust them, but it can be a collaborative process where they're better educated on how to faithfully take your brand, because we know our brand, they know their market. So I think that's when it goes well. A couple of quick little examples. In Mexico, some of our amenities for our more expensive membership don't really translate. Not a lot of people use tanning and some of the other amenities, but we're able to do haircuts as an amenity, and that didn't work in the US. It's just too expensive and operationally difficult. Pretty simple there, and it's been huge. In Australia, tanning's also not a thing there. It's actually illegal, but we've been able to offer spray tan, and our entire membership is close to what you pay for just one spray tan. So that's been great. In terms of system-wide changes and rollouts, we're very careful. Our general rule of thumb is just because we are rolling it out in the US, it does not mean we are rolling it out anywhere else. I think it's a market by market approach because we've been here for 30 years. We've been in some of these other markets just a couple of years. So our rule of thumb is it's not a system change, it's a market change unless we say otherwise. So those are just some of the examples I could think of, but this is a tough topic.
Yeah, great examples, Justin. Joyce, what do you, any thoughts from you on system change and market
Sure.
adaptation?
So Justin, those are really good real life examples. From a contract standpoint, and this is one observation, probably besides joint employer, system change is the most talked about issue domestically. And there's likely to be, if we don't get on top of it, from a franchise community, some legislative action that will deal with system change. So it's a very important issue, because from the franchisee's perspective, doesn't want to be surprised, blindsided, or have to invest in changes that don't merit it from a business case. Franchisor's perspective is its system, and it's got to be able to respond, evolve, and pivot. It's necessary to meet competition. And a lot of people think that the market competition will take care of these issues. But once a franchisee is locked into a contract and then there's system change, there's not a lot that the franchisee can do about it. So in anticipation of that, what I see on an international basis is that there is a lot of fear of these provisions concerning system change. And they usually deal with a couple of categories, well, probably 3 or 4 categories, dealing with modernization overall, computer systems, the marks and signage and decor and that type of thing, and then policies and procedures and overall changes in standards through the manual. What I see people do is want to put caps on modernization, computer system changes, that type of thing, have a sharing of expenses related to marks and signage changes, want to have some time periods in which those kinds of requests can be made, like if the term is 10 years, do it every 5 years, something on that order. And it's meaningful to people because they want to be able to budget for these kinds of potential expenditures. I think the biggest issue is notice and ability to phase in on change. And I know that a lot of people want to be consulted and talked to before there's changes made. That's not a realistic, I think, request. But I think having a business case for the change and doing it in a way that allows the franchisee to phase in the change appropriately, then that kind of takes the sting off of the request to be involved in the discussion about whether the change has merit or not, or how it should be implemented in an international context. Because for the most part, the change is probably highly likely one that has been adopted for the domestic market and is being now transferred over to an international market. There's just not a whole lot of discussion to have. If it's a change, it's a change, but it's how it's implemented, I think, is the most important thing. So some rapport with the franchisees internationally is, I think, very important, and especially in really large systems, the international franchisees know what's going on domestically. They see it happening, and they're all talking, and they're watching to see what kind of communication they get. So it's something that I think it is reasonable for a franchisor to look at a term and think about what the big capital expenditures might be, the likelihood of making changes, which computer system or anything technology related could happen on a very quick and often basis. So you have to preserve those rights and not negotiate those away. But I think taking a realistic view of when those things and to what extent they're going to be implemented is going to be critical.
Yeah, Joyce, it's interesting and maybe not a coincidence, but all those examples you raise are definitely things that in both international negotiations of setting up the agreement from the start, and then the ongoing operations are absolutely areas that have come up in my experience. And one of the things when I was thinking about this topic, and particularly the pairing of system change and local market adaptations, is that when you're first entering a market, if that's the position where you are, there's a lot of discussion, at least in my experience, and hopefully, and I would recommend a lot of discussion around local market adaptation. And there's that recognition that what works in the United States might not, assuming your home base is the US, that what works in your local market might not translate perfectly into another market. And like Justin, I've spent a lot of time in fitness, and in fitness, the penetration rate of fitness memberships across the globe varies wildly. So where in, the US, Canada, Australia, the Netherlands, you might have 20+% of the population that is a gym user. You go into, Latin America or certain parts of Asia, and that might be less than 1% of people who are experienced in going into a gym. And so in that early stage where you're talking about local market adaptation, there's a lot more work that needs to go into understanding, the building the awareness of, what is a gym? What are workouts? What is a push-up? I mean, things that to us, if you just start, are, I think, even as a consumer, are just hard to imagine until you get there. And so in those early discussions, you're having a lot of conversations, maybe it's about, in a restaurant world, it's about what products are available locally. Oh, in India, we're not going to have beef on our menu. In that initial setup, you're having really in-depth conversations very early on about what does this brand look like in the local market. And the approach, in my view, of both parties in having those early discussions tells you a little bit of something of how they're going to act in the long term. But sometimes maybe operationally you forget once you get going that system change has that same concept. So if you're rolling out a system change, it needs that same evaluation. So, and then that's a concern. And there are more layers to that discussion when you're dealing with international. And so some of the things that have worked well, at least for me in my experience, is to have those early conversations and to use that approach in your early conversations to set a structure for how you're going to address it in your franchise agreement. So when you're looking at local market adaptations, we made a whole slew of those in the first round. But as things go, what is the process that a prospect might use? And so building into the agreement a process where you can't possibly know every change you're going to have to make for the next 20 years. But you can know how are you going to approach that. So having a term negotiated in your agreement that talks about how you're going to address those, what's the nature of the change you need? Why do you need that change? How are we going to address it? What's the impact? What are the considerations we're going to use when we're making that change? I found that to be helpful to have that structure so that we start having those conversations. If they're not going particularly well, you can pull back and say, oh, we have this structure that we're going to talk about. And then in my experience, people do pretty, it helps diffuse some of the tension and give you a pathway to have those discussions down the road and up front. And some of the other things that I've seen addressed have been helpful is things like is in sourcing. Where in the US you might say you need to use our approved suppliers. You're going to need local sourcing. Well, you're still going to want to approve especially for key things. But when you're dealing with sole supplier, can you identify upfront core and sole source suppliers where it's very unlikely you're going to approve any change and the things, and that can give a level of comfort to your master franchisee around the flexibility that they're going to have, and the flexibility they're not going to have, that you have that conversation up front. Any other follow-up thoughts, Justin or Joyce?
One thing to add, for us, because we have a meaningful stake in, so we own about 260 of our 2,600 clubs. we have a provision in our agreement that basically says we won't make you do anything we're not willing to do ourselves. So doesn't always get us there, but it certainly helps. So I think when it comes to system change, that lends us direct credibility. But we do still get the, international franchisee heard this change domestically. When do I get to do it? So I got that call last week.
Yeah, that's great, Justin. I like that. Okay, well, let's jump to our next topic, which is all about getting paid. Joyce, do you want to lead us off on your experience negotiating around getting paid?
So this is at the same time my favorite topic and my most hated topic. And it's because there's so many moving parts. One would not think that just getting paid would require so much thought, but it does. And for the franchisor, that's the ultimate goal here. At least one of the most important goals. I don't want to say that having a successful business is not important, but certainly getting paid for licensing the system is a critical point. And so in the agreements, lots of different issues come up. So, for example, you want to establish what your currency of payment is going to be. And everybody's going to say in their mind, well, of course, that's US dollars. It is 99% US dollars, but there are some times where that is not the case. So, but to the extent that you are getting paid a royalty, then that's not flat payment in US dollars. So that's based off of local currency, and therefore there has to be an exchange. And you're going to want to consider the exchange rate that's going to be applicable, either by a standard that's already been established, which many times in countries is aligned with the US standard, or by virtue of some publication or resource, or bank can be a barometer or benchmark for establishing currency. And then there's currency risk. And most agreements say that, the volatility and currency risk is allocated to the franchisee, but what does that really mean? So if you don't establish some sort of minimum payment that you're expecting to get from your royalty stream or a percentage fee payment stream, then it's going to be very difficult to establish what the currency risk is and what the franchisee is responsible for. And most franchise agreements don't have that minimum in there. So give that some consideration if you really are thinking about being in a currency volatile market and you want to protect yourself from the currency risk that might be going on at the time that you're negotiating the deal. And you can't do it through some other banking artifice. You want to allocate it to the franchisee. It's going to have to be specifically tied to some sort of minimum payment. The other issue, one of the other issues is whether the fee is actually remittable. In other words, can it be paid to you? And this sounds maybe peculiar, but there are some countries, including India, where certain payments that we might describe as typical to our deal have to be restylized because to leave them as currently characterized would subject them to central bank, you can tell where I shop, central bank approval. And so you don't want that because it's very difficult in certain countries to get the central bank approval, and you want those fees to be remittable. So you have to take the time. I know that when I do a deal in India, I take all the fees and I go through them and I recharacterize them based on my experience and local counsel advice and what is likely to be enforced through an authorized dealer so that the franchisee can pay it to you. Another issue is stamp duty. There's been just horrifying cases where counsel has forgotten to make the franchisee, if that's the case, or the franchisor, somebody responsible for stamp duty or the tax that is imposed upon the value of the contract. In some countries, this can be considerable, so you need to be allocating for that. It's important to keep in mind that there's some countries where there are actually caps on the amount of the initial fee and ongoing royalty or percentage fees that you can get. Pakistan is one of them. So in those countries, you have to look for assets outside of the country in order to get paid. There's some countries like in Lebanon where you have some significant history of exchange controls that has really messed up the banking system. So you always want to get paid from what are called fresh fund accounts, which are like post 2019 bank accounts where funds are. So these are what I talked about before, kind of these little hidden issues that if you don't realize they're there, you're really jeopardizing your revenue stream. The other area that I want to talk about is how do you secure payment? And, a lot of franchisors rely on personal or corporate guarantees. I think it's important in that regard that the due diligence is just so incredibly important because you have no idea what that paper is worth. And will normally require a lot of monitoring, even if you put covenants in there that have to be met in order to have some sort of sense of what the asset position is of the guarantors. It's very difficult to monitor, and you can end up, being in a situation where you are 5-10 years down the pike and you want to execute or enforce a guarantee, and you find out your guarantors have either disappeared or assetless because it's difficult to monitor. So how do people compensate for that? And this is, I think, very, very important where you have countries in which they have legal systems in which you would never want to have to, litigate or arbitrate an issue like this. And so I as a rule of thumb, and thankfully, over the years, it's become easier and easier to do, is when I'm in a legal system that I don't have a lot of sense of reliability in, then insist on a standby letter of credit or a bank guarantee. The bank guarantee is a tool that is not offered by U.S. banks, but is available in international banks. It is not as good as a standby letter of credit because it's one way. It's a bank giving you a guarantee, and there's no confirming bank, and there's no replacement or replenishing of the bank guarantee unless you provide for that by contract. The standby letter of credit is a great tool because you have an issuing bank who is normally the franchisee's bank talking to your bank, which is a confirming bank, and the confirming bank is giving you the comfort as the franchisor that you're going to get paid. And the standby letter of credit is issued on that basis, and the confirming bank is actually the bank that makes the payment. This sounds wonderful, and a lot of experienced franchisees are used to this, and it's getting used more and more. But it does take an extra bit of negotiation. You want to have your standby letter of credit and your bank guarantee type language always already in your documents. I put it as an exhibit saying all the different conditions that have to be put into the letter of credit. And I have a template letter of credit that we give the franchisee to take to their bank. Most banks have their own standby letter of credit, but having ours helps them see what we need to have in the standby letter of credit, and then they can let us know what it is that they need in order to provide one to us. The biggest issues that we see with the banks is they don't want replenishment. So a normal standby letter of credit is 12 months. And normally it would require it to replenish if it was a drawdown on the standby letter of credit. And banks just don't want to do that because that increases their liability significantly. So in that case, you have to just make sure that you have in your that each time the standby letter of credit is up for renewal, it's replaced before it expires. Kind of a standard point, but it's nice to have it can be replenished, but at least to have it replaced is important. I think I mentioned guarantees a little while ago in terms of local law. I recently ran into a situation where I was surprised that under that local law, I had to have a cap on a guarantee. Normally it's the franchisee who's looking for a cap or some sort of burnout on the liability under the guarantee. But here, in order for it to be enforced in the country, it had to have a cap. So the franchisee was very surprised that we came back offering a cap for our own purposes, but we had to in order to make sure it would be enforced. I think the upshot of what hopefully I'm trying to, and I am getting across, is that payment terms are critical. and they need to be dealt with upfront because they take time. So there are some countries, like we're dealing in Uzbekistan right now, where you have to have special invoicing and certificates to get the US dollars out, even a flat payment. And just in using their forms and dealing with the time constraints that are imposed by dealing with government authorities to get those dollars out. So building in to the contract, knowing that you're going to have these documents that need to be produced and the time requirements that are going to apply helps you stage your terms better than dealing with it post-execution. So I'll leave that at there. I know that's a big mouthful, but it's just a really critical area that from a business standpoint can make or break a deal. Oh, and let me just add this. One point I didn't bring up was the gross up. So I talked about gross up being one of those points that people seem to forget they're in the contract. So the franchisor wants to prepare an invoice that already has the grossed up amount into the total. So when the franchisee receives it, they're paying that grossed up amount and then paying the taxes to the authorities. I get that question all the time from both sides on how this is supposed to work. And many times that can be the first time that the franchisee realized they're paying a gross up. So this is why it's really important to talk this out, even if it's uncomfortable.
Thanks, Joyce. Justin, any thoughts on getting paid?
I like it. I'll be quick. I think naively, I like to think as a business person, like just make the money and the accountants can go account. They'll figure it out. And there's certain people on my team, I want to think like that, where you worry about an arrangement that makes the money. We'll figure it out. But in reality, I think partnering early with a franchisee counterpart, and whether it's accounting, tax, reporting, all of those individuals, if you can loop them in early enough, those conversations should start way earlier than what we've done in the past, and earlier than you probably think. So getting them involved early is helpful. This seems like, oh, they'll figure it out, but it does come with some real headaches, and we've dealt with a lot of those.
Yeah, I agree. I've had that same experience. I'll just quickly add a couple of things. So one is like we all do think getting paid is important. I very early in my career, I once saw an agreement, an actual in-force agreement that said something to the effect that the master franchisee would pay some number of years later, I think it was 2 or 5 years later, if they were happy with the business. That was the payment trigger for paying. And I'm not sure that person ever admitted they were happy with the business. And so, that's maybe not the starting point, but it's a pretty extreme example to say we really, getting into the payment details is not necessarily fun, and can be a challenging discussion. But also, the approach that I've often taken is, to the extent that we knew things, we tried to come to the table and start with the terms in a place that are already balanced. So things like a gross up, say like I haven't really seen a full gross up in my experience, which I think may not be fully representative. And it was hard, particularly when you're both the legal counsel and in charge of development. You can't really say my legal department makes me have a gross up, right? Like that you are both, even if you defer to people on your team where there's a conflict. So you have to address those things really from straightforward. And so, a good solution on gross ups in my experience is to understand what the withholding taxes are in the country, understand if you can take a tax credit against those, and if so, to have what I call I don't know if it's a real term, I've just called like a leaping gross up, which is to say, look, we're not going to charge you a gross up on your fees. You pay the withholding tax, get us the documentation we need for us to claim on our tax credit. If you don't get us the documentation, or actually pay the taxes in the local market, well, then you're going to be responsible for this or come back for our gross up. So
So
I found
that's a
that-
good point. That's a good point, Ellie. Very few companies qualify for a foreign
Yeah.
tax credit. So it's something that needs to be, checked out at the beginning, but I have seen that work before.
Yep. Yeah. All right, well, let's jump forward. And our next topic we want to talk about is development schedules and the consequences. And so I'll just introduce this to say in my experience in from both the business, especially from the business perspective of setting up relationships with people, is development schedule is a very significant portion of the discussions very early in the process. And quite frankly, it's a huge part of the main point of why you're entering into an agreement. And your goal is really to clearly define the expectations of both parties. And those discussions around the development schedule is a great opportunity to assess your goals, whether there's alignment in your goals with the person that you're considering as a potential partner, and to understand whether you share a realistic vision for the future of the brand. And again, as part of, almost as part of the due diligence, to understand how are they thinking about, how is your counterparty thinking about development, and is there a good alignment and fit on that? It can be a helpful part of the vetting process to have those discussions and to understand, are you kind of on the same page? Which then transitions you to the next stage of documenting your development schedules, which can be a little bit more challenging because there are very real considerations for both parties. We're aligned on both sides. Say, look, as the brand owner, I want to maximize the opportunity in the territory. A master franchisee or an area developer, they wouldn't be seeking the opportunity if they weren't planning to grow, hopefully, in the usual case, if they weren't actually planning to grow and expand. But it's also one of the biggest risk factors because there are sometimes things outside your control in development. Say COVID, for example, is a really extreme one. And so that risk on your partner side, it is a very real one. So a couple basic things on development schedules is, you're typically looking at how many locations are you going to open over what period of time, and how many are then continuously operating. So the cumulative total. You might require that someone, if you're in a master franchise understanding, are you going to require corporate locations first? What is the scope and scale of development? And just knowing there are things that change along the way. So when I've been looking at development schedules, and working through those, both as an attorney and as and in my role in development, is we kind of take. I don't think there's one right way to determine development obligations or to draft development schedules. You really have to understand your goals, the resources of the parties, assess the facts of your situation, kind of understand the options, and then put that into a structure where you're very precise, but you've allowed for flexibility in ways that you agree. You want to be realistic about your rate of growth. And then just an understanding that during the course of a long relationship, you might need to renegotiate. And so, looking at things, well, if things don't quite go right, how do we address that? Is there a cure period? Do we have a force majeure clause? If something outside of our control, again, COVID, wars, right? Big natural disasters. What is going to lead to an automatic suspension or extension of the development schedule? Is there an option to have an extension, but to pay a fee? Is it the nuclear option? If you're not meeting your development schedule, you're terminated. If so, what happens to the existing locations? Are there damages for failing to move forward? Is there a remedy for you as the brand owner that falls short of the nuclear option of termination? Is that modification of the territory? Are there other actions you might want someone to take to show their good faith in moving and growing forward? Something that you can put in place. And then kind of the flip side is, when you, I don't know if my experience is everybody's, but my experience has been that when you start talking to a partner, especially people who approach you and really want to take your brand into another country, I've always built very early into the process that we're having our potential partner present and share their idea of the business plan for the market, which often includes what they think market capacity is, which are usually very optimistic numbers. And I, can recall several situations where I'm sitting back at the table and I think in my head, wow, that's optimistic. Amazing. Sounds great, but optimistic. And when you get down the road to negotiating the actual development schedule that goes in the agreement that has consequences built to it, those numbers look a little bit different. And on the one hand, you might say, hey, there's a little there, why did that change? But one of the approaches or something to think about that has been successful for me in a few cases is to say, I knew the development schedule was optimistic, and then it exceeded what we would have perhaps suggested ourselves. But it would be great if we could achieve, greater results than we were thinking. And so building in one approach I've taken is instead of building in consequences to a moderate development schedule is to have a moderate development schedule, but with incentives for overperformance. That is one way to kind of balance that push-pull on risk versus the risk on the master franchisee side versus your hopefully mutual desire, and certainly the franchisor's desire to penetrate and have a market presence that aligns to the full potential. So those are a handful of thoughts from me on development schedule. I don't know, Joyce, in your experience, what do you see? I think you're typically getting deals when things have already reached a certain level of negotiation. What do you see at that point?
Well, I agree with you. I have a client who on a consistent basis builds in a premium or an incentive for early development as well as on-time development. And it normally takes the form of some sort of waiver of fees or additional units being made available to them. Whatever the win is in the eyes of the two parties for exceeding expectations is on the table. So I think that works well, if not used too much, because a lot of times it can set the stage for thinking that every time you do your job or you perform according to the contract, you're going to get some sort of additional benefit than you've already contracted for. So you have to just use that with some measured results. With respect to development schedules, I guess three things. One is I think there are different philosophies on whether or not you establish an overambitious development schedule from a franchisor standpoint, because you're kind of in control of what happens if in fact there is a failure to meet the development schedule. So there's not a whole lot that you're giving away as long as you can deal with the negotiation of that default and not lose out because you gave exclusivity. Many times franchisors provide for the eventuality that there's going to be additional time required and put in some optional extensions that can be requested. And many times those are paid extensions. So, for example, one extension of 6 months is on us. And if you need another extension within the development schedule, it's for a certain fee. Also, franchisors tend to use liquidated damages in this context. And so if you have undeveloped stores at the end of the schedule, then there'll be a statement or a formula for calculating what those damages would be based on the fees that would normally be attributable, from that store. Could be just the franchise fee, for example, or the development fee, times the number of stores that are not opened. And so that is a statement of damages that franchisees have to look at carefully, because they understand it's not going to be just a remedy of termination if they fail to meet the development schedule, but they also are going to be responsible for some level of lost revenue.
Yep. We are approaching the end of our time, and it's been a great discussion. We haven't gotten there, so we don't have any questions in the Q&A. So I'm going to give it to Justin to give us our last words on this topic, and then we'll close out.
Sure, I'll keep it brief. It's developing a schedule of part art and science. It's difficult. You're not going to get it completely right. Focusing on franchisee profitability in their units is the best way to ensure a lot of developments and well-capitalized franchisees. You're trying to match the commitment that you're giving them with their, skills, ability, expertise, and capital resources. I like to make the development agreement as short as possible, and I'm willing to be more generous with my renewal provision to keep a short agreement. I think that can work. And I like the kid approach where, eat what's on your plate and then we can talk about dessert. So I know you want this territory. If you prove it out here, we'll hold this for you, and you can also have that. And lastly, on damages, I think the damages for failure to develop sound really good in a conference room, and in practice are really not a great thing. Not something I would advocate for.
No, we totally disagree there.
Yeah, we had to have done something. Yeah,
I know.
we haven't yet. So.
Yeah.
That means that you're not suing for the failure to open the stores. So you're going to let that one go. And I think it's important to get that point across. I agree with you that if you're not going to exercise those remedies.
Yeah.
Yeah. Great. Well, there's so much more we could dive into there, but we have reached the end of our time. So really great discussion. Thank you both for sharing your experience and your wisdom and the different points of view. Thanks to all of you participants who attended and participated. We do have the contact information for our panelists here is on your screen at the moment. If you have follow-up questions, feel free to get in touch with us, and keep an eye on your inbox. The International Committee is putting together additional webinars through the course of this year. So keep an eye on your messages from IFA, and we hope you join us for those. Thanks, everyone.
Thank you.
Thank you. Take care.